on the topic of the Mediation Act 2023, game changer for resolution of corporate disputes. Friends, as you are aware that since 2020, we are organizing continuously on every Friday our webinar on different topics of corporate interest. And this is our 147 webinar without fail. On every week, 4 to 6, we are organizing these webinars. Friends, the Mediation Act 2023 has been enacted to promote mediation as a preferred mode of alternative dispute resolution. The Act aims to promote and facilitate mediation, especially institutional mediation, for resolution of disputes, commercial or otherwise, enforce mediated settlement agreement, provide for a body for the registration of mediation, to encourage community mediation, and to make online mediation as an acceptable and cost-effective process. Friends, the Mediation Act 2023 makes a significant milestone in the evolution of conflict resolution in India, especially in the corporate sector. Besides, it is yet another step in putting India on the global map as a dispute-friendly jurisdiction. And in future, we can see that India can be in a world where time is money and efficiency is key. The Mediation Act 23 stands as an important hope and the catalyst for change. This act does not merely signify legal reforms. It represents a shift in how we approach dispute within the corporate landscape. This groundbreaking legislation opens door to efficient, cost-effective, and confidential dispute resolution by emphasizing the role of mediation. It offers corporations a proactive and agile approach to address conflicts. The Act allows parties to preserve relationships, save valuable time, and maintain confidentiality while finding mutual beneficial solution. Under this Act, parties have the freedom to choose their mediator, ensuring that the resolution process is tailored to the specific need of the dispute. It introduced the concept of community mediation, emphasized the importance of harmony and peace in local environment. Additionally, the Act promotes the use of online mediation, eliminating geographical barriers and making resolution accessible to all. In today's fast-paced corporate world, effective dispute resolution is not only a legal necessity but a strategic advantage. By swiftly resolving dispute, corporate can redirect their focus on resource towards innovative growth and fostering a strong business relationship, which is the need and the hour of the corporate. So the Mediation Act will be a game changer for the resolution of corporate dispute. The objective of the webinar is to discuss the key provision and implementation of Mediation Act 2023 and to shed light on the potential impact on the resolution of corporate dispute in various legal complexity. Today, we have gathered some of the brightest mind and expert in the field of mediation to share insight, case studies, best practices together. We will devolve upon the nuance of Mediation Act 2023, understand its implication for corporate entities, and explore how it can transform the way we navigate dispute today in the corporate world. Friends, today I just told you that we have a best of the mind in this industry. So first I welcome Mr. Mohit Mathur. He is a senior advocate and a president of Delhi High Court Bar Association. And he is, you can see his name, and he is appearing in various prominent cases in India. I welcome Mohit for this program. Then we have Ms. Veena Areli. She is Organizing Secretary, Samadhan, Delhi High Court Mediation and Conciliation Center, and she leads over 260 empaneled mediators. She has also been appointed mediator in several important large commercial and family disputes by Supreme Court and the Delhi High Court. I welcome Veena Madam, and I hope that because you are the right person for this program, so your experience will definitely helpful for understanding this law and using this law. Then we have Mr. P. Nagesh. He is a senior advocate with 26-year experience in corporate law, advisory and litigation. He is a research-oriented person and represented wide area of complicated nature in various Supreme Court, High Court, and NCLT. I welcome Nagesh. He is on tour to Badrinath, so he will join us shortly. Then I welcome Mr. Amit Khemka. He is practicing as a litigation lawyer in Supreme Court, High Court, and other courts of country, and has handled large number of cases involving complex issue, some of which are made headlines also. I welcome Amit Khemka ji. Then we have Mr. Vinay Sanduja is a registrar India International Arbitration Center. He is also another person who is handling these types of cases and who is the best person to explain us. Vinay is a legal professional and diverse experience with specialization in the field of corporate and commercial litigation, arbitration, competition, and insolvency law. He graduated. He is regularly speaking on arbitration, competition, and insolvency law. I welcome Vinay for this program. Then we have a Ravi Prakash. He is an advocate and associate partner in corporate profession. He is expert in security law and litigation and arbitration, mediation, in family settlement. He is a part of various cases. So friends, I encourage by you to all actively participate by sending your queries, because all these people are here. This is the new law. So all the participants, those who have come, please send us so we can ask and take this opportunity. So the program structure will be like this. First, I will request Mr. Mohit Mathur, who is the Delhi Bar Association president, and he has a wide experience and experienced person in this. He'll give opening remarks. Then I will request Veena Madam, because she is looking after this entire gamut. So what is her call on this particular issue? Then Mr. Amit Khemka and Nagesh will discuss about the corporate laws and mediation, and then Ravi Prakash will discuss. Before Mohit Mathur, I just missed it. Vinay will give a brief introduction of this particular mediation law, so it will be useful for all of us. Friends, as you are aware that this topic is new, and there are so many issues like online mediation, compulsory pre-litigation, what is falling and what is not fitting in this, 180 days plus 180 days, that is a timeline sanctity, fit final and binding order, whether it's possible or not, and then Mediation Council of India, that is a plan. So today we will discuss all these issues and how the corporate world can utilize this opportunity, and in my opinion, employment dispute, contractual dispute, shareholder dispute, merger and acquisition dispute, intellectual property right dispute, corporate governance issue, partnership dispute, supply vendors issue, regulatory compliance, data breach and private matters. These are certain issues where the corporate world can take advantage of this particular law. Simultaneously, we should also understand that there are so many areas where this law is not applicable, where you can't do. And especially for the professional, we should understand that if there is a bar council is taking action against somebody, or institute of company secretary, chartered accountant is taking any action, then you can't refer for mediation. Then you can't go for, if SEBI is doing, CCI is doing, and TRI is doing, then you can't go. So all these things we'll discuss today. With this thing, I'll request Mohit to give his introductory address to all of us. Over to you, Mohit.
Good evening, everyone.
Good evening.
In fact, with Veena ma'am there, I don't think we needed anybody else to speak on mediation law. She is fully not just equipped to handle all the aspects, but perhaps has held the reins of the Samadhan, the Delhi High Court Mediation and Conciliation Center, for so many years, so ably and successfully handling it. As far as whatever I have understood about the Mediation Act 2023, I'll be speaking only on the limited aspect of the applicability of the same in criminal law, because mediation, as we understood till now, was coming into operation and being used in several criminal cases as well, where the parties wanted to put a quietus to the litigation, their disputes, and sometimes also lay down a path for their future acts as well. This Mediation Act 2023, though the objective is very laudable and the purpose they wanted to bring in sync with the Commercial Courts Act, where pre-litigation mediation is mandatory. The concept here seems to limit itself only to those cases where there's a sort of a dispute between the commercial parties, or cases which relate to probably parties not affecting the much of the criminal side angle of it. Because what Section 6 excludes in this, what will not fit, the first thing that they do in the first schedule is to eliminate all criminal prosecutions. Although one look at the Section 6 proviso talks of doesn't prevent the court, but to refer these even criminal disputes, if appropriate, if deemed appropriate, that's the language used, from referring such relatable to compoundable offenses. Now, this is where I somehow feel that this Mediation Act will be narrowing down the scope of mediation, which we have understood till now, and used to the hilt, even in cases which law may not make it compoundable. And this is where I've always found the mediation helpful, because it probably seeks to secure justice over and above law. And this aspect of mediation should not have been forgotten. And I don't know how the courts will appreciate and interpret the proviso to Section 6. Because Section 6, in a way, curtails the references to mediation under the Mediation Act. If the justice is to be secured, then the courts will need to, and the lawyers will have to contend and argue that this word compoundable should be given a larger meaning, more not as limited to what is under Section 320 of the Criminal Procedure Code, laying down what are compoundable offenses. Because if one sees the language of the proviso, it says relate this, and it can refer any dispute relating to compoundable offenses, including matrimonial offenses, which are compoundable and pending between the parties. Now, an error which seems to have crept in is, normally the matrimonial disputes involve 498A, capital A, of the Indian Penal Code. Now, by some inadvertence of the legislature, I can only say that 498A is still not compoundable under the Section 320 of the CRPC. So if we were to settle matrimonial disputes in mediation, that's the first thing where the scope has to be enlarged. Because if this proviso is to restrict even those offenses, then I dare say it will be a problem. Because today, and Veena ma'am may be correcting me, because one of the statistics I saw was that nearly 1/3 of the matrimonial cases that reach mediation get settled. She may be able to correct me. But if that large is the number where mediation is successful in sorting out the disputes between the warring family members, then there is no point in restricting the scope of mediation for future purposes. And this is one part where the courts will have to examine the Mediation Act in that light. Another aspect is there are certain less severe crimes. And when I say less severe crimes, it is not merely by way of the punishment, but also by way of the impact. It could be trespasses. It could be neighbors' disputes, landlord-tenant disputes, where there's a spillover. Certain civil transactions have spilled over into the criminal law. Those, some of them are compoundable, the others may not be compoundable. So again, I would say the restriction of this will impact deeply. When somebody wants to have a wholesome settlement, there would be offshoots. And the offshoots may be transgressing into the criminal side. And those criminal offenses may or may not get covered by the word compoundable. So my request and for everyone's understanding and for everyone to beseech the courts is to enlarge this aspect, that let us not limit it to the compoundability, but see the impact of the same. There are crimes where now with the amendments, the juvenility is also reduced from 18 to 16, and that period, 2 years, is being considered looking at the offense. Now, if these people, these juveniles, are to be given a future and some sort of a lenient look, then I would say that the court should, in fact, look for an approach these offenses also with a lighter hand and probably extend the benefit that mediation has been giving till now. And those who are into active mediation, I for one am not. So my experience may not be that much, but as a recipient, that is as a counsel whose clients have gone in for mediation, I feel that certain, after the emotional outbursts that the parties may have when they sit together, so even if there are criminal cases between the two and they are at loggerheads, I have found that they come out with a lighter mind, lighter heart, having expressed themselves, having blurted out what they have in their hearts with each other, and patient hearings given by the mediators, who for one I know have been trained accordingly to listen, to be good listeners. Somehow I have found some very, very tricky cases on the criminal side also have been solved, because those cases may not have an impact to the society. So perhaps the impact should be the judging point, that what kind of cases can be referred to mediation. So totally sweeping removal of criminal prosecutions from the mediation would not be a good approach. According to me, this proviso should be interpreted by the courts to include all those cases where the reparation of the harm can be done. It's something where restoration can take place. The losses are of the type which can be covered, and people can walk the few steps extra and somehow come to a meeting point. So when the chapter of plea bargaining is introduced as a legislative amendment, and the courts are encouraging people to bring a quietus so that the litigation is also concluded, the prosecutions don't continue, the stigma doesn't go on forever. In that kind of a scenario, having given an option in cases up to 7 years punishment to go in for plea bargaining, there's no reason why the Chapter 3, Section 6 proviso should be limited only to compoundable cases. Because if we can reduce, and there are people who feel remorseful after having suffered maybe a 3-month custody, 4-month custody. And at that point of time, and the person who's affected also feels that that's enough sentence or enough punishment for the purpose, for the harm that was caused, the injury that was caused. When the two parties are willing to give it an end to it and bury the hatchets, I don't think there is any reason for restricting the scope of mediation, because the aspect that needs to be considered is, if one has to be given a decent, the dispute has to be given a decent burial, then the person who is said to be the offender is also will be getting a chance with mediation. He gets a chance to get a clean slate for future. So that kind of a option should also be, I think, high up on the priority list. Because, as I said, you have to see and give justice a higher platform and pedestal than the strict law. Because the strict law may not consider things, and Veena ma'am can elaborate. And I have had umpteen occasions to hear them out, where they say that things which courts cannot solve are solved in mediation, where the law may not provide the person with the remedies and the returns that he gets out of mediation, they've got from mediation. So with that objective, to consider the commercial disputes to be brought to an end, there's no reason why the less severe offenses should be kept out of the mediation loop. And there is now, with the mediation in Delhi itself having been 16 years old, so I think we have competent people who can handle even the criminal prosecutions and understand the victim versus the offender balance and how to mediate. So that's my take on this act, because the challenge available under Section 28 will render any kind of a mediation under criminal law nugatory, because if you refer it and the challenge under Section 28 says one of the grounds is that it is not fit for mediation under Section 6, then all the things will go. So there has to be some kind of a balance which needs to be drawn. That's what I feel on this Mediation Act, on the angle of criminal law. But there are other experts on the panel who can take care and who have the experience about the mediation in the commercial disputes and other fields. That's my take on it. Thank you very much for giving this opportunity.
Thank you very much, Mohit. Thank you. Just your view. Do you see plea bargain, which is applicable in other part of the jurisdiction, will come into India as a mediation point?
Pavanji, I have always been a subscriber to this subject of plea bargaining and mediation in criminal law, for the reason there are two aspects to it. Plea bargaining doesn't remove the stigma of conviction. For a person who is not getting anything else, I think plea bargaining may be a soft way to restart his life, because we cannot keep people behind bars and to keep them under the sword of Damocles of the prosecution hanging on their head. Because as a society, we need to understand that if there is a person who is remorseful, he should be given an opportunity to restart his life afresh. And mediation, I found, was perhaps a much better solution, because mediation allows you to totally clean the tracks behind. Because after mediation with the victim, you can perhaps go in for a quashing which wipes away the stigma. and that stigma may unnecessarily affect his life in future. So where it is not affecting, plea bargaining can be worked out. But why restrict mediation in cases where things can be sorted out? And maybe criminal law may be just a part of the bigger dispute. So the entire bigger dispute may not get resolved because this will be a spoke in the wheel. So let's think of things which are a wholesome probably remedy. So plea bargaining takes you 2 steps, but mediation then helps in going 2 steps further.
Okay. Okay. My last point, because I know you have to go for another meeting. There are so many things which is popular in mediation criminal law, like victim offender mediation in another part of the world, diversion program, the restorative justice, jubilant justice, community conferencing, pre-trial mediation. These are all international things which is happening. Now in India, in mediation law, they are saying criminal law will not be the part of this. So do you see any future that some part of the criminal law will be the part of the Mediation Act?
That's exactly what I said. When if the courts were to look into it, and as counsels and as mediators, probably start giving these suggestions. Maybe this is just the beginning, that they want to formalize mediation, but by way of an act and institutionalize mediation. But I am sure when recommendations will be made to enhance the effectivity, because what I just gave as an example, that the disputes may involve both commercial as well as criminal angle. And how do you resolve the dispute completely unless and until you give a quietus to the criminal side also?
Okay.
So there has, I think both the courts, the lawyers, and the legislature will have to wake up to it. And we have to somehow ensure that the present day mediation should not be restricted by this act. In fact, we must make it better. Okay. You may have institutionalized it, but whatever they are doing, a good job that they are doing, don't restrict it by limiting the scope.
Okay.
Because and Veena ji can give you the statistics. I know of hundreds of cases which I have argued, gotten them referred to mediation, and they have come back all settled, everyone happy, everyone gone back home. Barring the lawyer's pocket, nothing has suffered. So
that's right. That's right. Okay. So thank you very much. Thank you, Mohit.
Thank you so much. Thank you for giving me an opportunity. Thank you.
Okay. So friends, Mohit has given you the intricacies, and actually his experience was speaking in the opening remarks. Now I'll request Vinay to give us your brief about this Mediation Act 2023, and then I'll request after that Veena Madam to, because I can understand when Mr. Amit Khemka ji has introduced me to you, and then I saw this, and everybody knows you in this area, so you are the authority in India on this subject. So we will definitely take. So when
Pavanji, we are here not as co-speakers of Veena ji. We are here to only listen to her. She is our trainer, you know. We are.
So Vinay, you just give us the feel of this law, okay? And
right,
then
sir.
I will request after that Veena Madam to explain us the basic issues on this. Over to you, Vinay.
Right. Thank you very much, sir. So good evening, everyone. Before I start, I would like to thank corporate professionals, particularly Pawan Kumar Vijay sir and Vinod Kumar Agarwal sir, for inviting me to this aptly organized webinar, which is very topical in view of the fact we just had 15 September, the notification of this Mediation Act. I will just, please allow me to project the PPT. Sir, is my screen visible, sir?
Yes, yes.
Okay,
Yes,
thank
sir.
you very much.
Carry on.
Yeah, thank you. So I will, because to make people understand the provisions, so I've just used the sections, which I will be just, okay. So I will just broadly say that this is a monumental shift to this process, this Mediation Act of 2023. And the main aim is to promote and facilitate mediation as an ADR mechanism. And it rather paves way for a swifter and more cost-effective dispute resolution, and it will ease the burden of Indian judicial system. However, we all know that the mediation is by the party for the party, and mindset of parties is very, very important. So preamble to the act, I will just like to quote, because though it is an external aid of construction in our law, but it gives us deep insight what the law intends to do. So it is an act to promote and facilitate mediation, especially institutional mediation, for the resolution of disputes, commercial or otherwise, and enforce mediated settlement agreements. It provides for that. And it provides for a body for registration of mediators, and to encourage community mediation, and to make online mediation, which is a very new concept which has been brought in the statute books, as acceptable and cost-effective process, and for matters connected therewith, incidental thereto. So we all know that Section 89(1) of the Code of Civil Procedure is on the statutory books, which provides the court the option to refer parties to the various ADR mechanisms, including mediation. So till date, no comprehensive legal framework existed. So this Mediation Act provides a legal framework which is comprehensive in nature. We all know that the Mediation Act received the President's assent and was published on 15th September. However, at the same time, if we see Section 1(3), it says the act shall come into force at different provisions. They may be notified at different point of times. So enforcement notification has yet to come. So we don't have actual implementation of the act right now. So before I proceed further, this act is not applicable if the proceedings are conducted by Lok Adalat and permanent Lok Adalat under the Legal Services Authorities Act. Again, just I will cover this a little more in detail in the coming slide. This was just there that it will promotion, facilitation of pre-litigation mediation, in community and institutional mediation. So these are the different categories of mediation which have been provided in the Act. And time-bound procedure has been provided, which we'll discuss a little later. Confidentiality provisions have been provided, and a regulatory body called Mediation Council of India to regulate mediators, mediation service providers, mediation institution is also provided. And the most important part is enforcement and challenge of domestic mediated settlement under the Act have also been provided. And domestic, it means that international international mediated settlement agreements are not covered. India is a signatory to the Singapore Convention of Mediation, which talks about enforcement of cross-border settlement agreement. But in the Mediation Act of 2023, it is still covering the domestic mediation. So first of all, this is very important definition. Mediation, it includes a process, whether referred to by the expression mediation, if you say mediation, if you say pre-litigation mediation, online mediation, community mediation, they all are covered as mediation. We can use the term mediation and it refers to all these expressions. And the most important thing is conciliation or an expression of similar import. So this is very crucial thing which has been included in the definition of mediation, that whatever conciliation proceedings happen, so they are also covered as a mediation. So that is in line with the international best practices. So mediation definitions categorically says where it is a process whereby the parties attempt to reach an amicable settlement of their dispute with the assistance of a third person, who is an independent person, mediator, who does not have the authority to impose a settlement upon the parties. So that is the most important catch, that he doesn't have the authority to impose the settlement, which normally we see in other things, that as an arbitrator or as a conciliator, you have the options to discuss, to make a particular mark on the minds of the parties. But here in mediator, his role is circumscribed to generate the options, which we'll discuss a little. So I've just skipped certain slides in the interest of time. Institutional arbitration is there, which means when the mediation is conducted under the aegis of mediation service provider. International mediation is the mediation which is undertaken under this act. So definition of what is mediation under this act will become important. So if the mediation is under this act and it's a commercial dispute, not otherwise, then the parties, one of the parties is outside, then it becomes an international mediation. That mediation has to be conducted. Yeah, that will come a little later. Pre-litigation mediation is also provided. It says that it is a process of taking a mediation as provided under section 5, with details out, irrespective of the fact whether we have a mediation agreement or non mediation agreement. Still, the parties may voluntarily and with the consent try to settle their dispute through mediation. And here you can see the difference. Here it is civil or commercial nature. So both the matters can be taken into account. So this is important. Applicability. It says that where mediation is conducted in India. So this is very important. The mediation has to be conducted in India, first of all. And then there are several options. You can fall under any of the options, but the first thing is very important, that the mediation has to be conducted in India. Then all or both the parties habitually reside, or companies there, so companies incorporated, or the partnership firm is that they have the place in India. So in 5 cases. So it can be another option that if the mediation agreements provide that any dispute shall be resolved in accordance with the provisions of the Act, then the applicability of Mediation Act is there. Or it is an international mediation. But to all these cases, the main important point is the mediation has to be conducted in India. However, there is a carve out for government things, wherein it says that wherein one of the parties to the dispute is central government or state or public bodies, then it has to be a matter of commercial dispute. However, when we go to clause number 5, it says that any other kind of dispute, if deemed appropriate and notified by the government, then it can be referred to a mediation. But the government has to be a party to it. Section 6, as Mr. Mohit Mathur sir also just pointed out, that there is embargo, that there can be certain matters which are not fit for mediation. So it talks about that mediation under the Act not to be conducted for resolution of any dispute or matter contained in the indicative list of the first schedule. So first schedule, there are certain items which are given wherein you can't do the mediation, and this list can be expanded because this is indicative in nature, as the legislature says. However, again, the compoundable offenses, Mr. Mathur has just now touched, that compoundable offenses, including matrimonial offenses, in any case, they can be referred to mediation. So that is an exception. But when we go through the list of the first schedule, it says that disputes which by virtue of any law cannot be submitted to the arbitration, they can't be going under the mediation under the Mediation Act. Then criminal offenses cannot be mediated under this Act. Then, as Pawan also pointed out, complaint or proceedings relating to the registration, discipline, misconduct of any practitioner, registered professionals, lawyers, company secretaries, chartered accountants, medical practitioners, etc. So they are not covered because there is a specific act dealing with that. Then disputes relating to minors, DTs, persons with intellectual disabilities, which are covered under the Right of Persons with Disabilities Act, they are also not covered. Similarly, disputes which have the effect on the rights of the third parties are also not covered. Similarly, any proceedings relating to the National Green Tribunal Act, Competition Act, Electricity Act, PNGRB Act, SEBI Act, land acquisition law matters, they are all not fit for arbitration. So they are excluded by virtue of first schedule. So we come to the pre-litigation. It says that subject to other provisions of the Act, where a mediation agreement exists, whether a mediation agreement exists or not. So you don't need to have a mediation agreement in place to go for the pre-litigation, because it's a voluntary, and with the mutual consent, they can take steps to settle their disputes. And when we say they can take the steps to settle their dispute, that means whenever you are resorting to any suit or proceedings under any court, tribunals, you can take recourse obligation as a voluntary mechanism and go by that. Then there is an exception in this section. We say that the commercial disputes of the specified value and which are covered under Section 12A of the Commercial Courts Act, they cannot be mediated here. They have to go through the process mechanism provided under the Commercial Courts Act. Then it talks about various other things. I will not be touching upon those things because this is all procedural, that the mediator has to be registered with the Mediation Council, or it has to be impaneled with Court Annexed Mediation Center or authority constituted Legal Services Authority Act and other things. So if we see this, so it says, notwithstanding the non-settlement of, 1 second, let's just, I will just put on. Yes. So it says the power of the court or tribunal to refer the parties to the mediation. Irrespective of the fact the mediation has failed in the voluntary mechanism, courts and the tribunals still have the power to send the parties to the mediation when the case comes before them, and then they can pass the suitable interim orders to protect the interest. Appointment of arbitrators, it can be divided into two parts, because here the Act talks about ad hoc arbitration and institutional arbitration. Because when the arbitration, I used the word arbitration. I'm habitually in the habit of using that. It is ad hoc mediation. My apologies. Ad hoc mediation, unless otherwise agreed by the parties, a person of nationality, any nationality may be appointed. However, if the person is a foreign national, then he needs to satisfy the accreditations norms which may be provided by the regulations by the Mediation Council of India. However, if the parties are not able to reach any agreement, but they want to initiate the mediation under this Act, they can make an application to the mediation service provider. Conflict of interest, just like independence and impartiality of the arbitrator is provided in the Arbitration Act. Similarly, mediator also has to give his conflict check. He has to give the conflict check prior to the conduct of the arbitration and during the mediation also, that there is an independence and impartiality on his part, and there is nothing which can raise justifiable doubts. However, the parties have the option to waive off any objection, but that has to be very, very expressly said. Then if the parties takes an objection, then it can be replaced depending upon the category. If it's an institutional, then the party has to apply to the mediation service provider. Otherwise, it can terminate the mandate of the mediator. So thereafter, mediation agreement. Mediation shall be in writing, just like arbitration agreement. It shall be in writing. It can be by way of a clause, or it can be by way of a separate agreement. And it provides the definition that mediation is recorded and signed by the parties or by virtue of emails and whatever is provided under the Information Technology Act of 2000, that becomes a mediation agreement in writing. An important thing is that whether whenever there is a pleadings and one party has said that the mediation agreement is there and the other party has not denied, so that is also a mediation agreement in writing. So that's the thing. And most important thing here, which is provided under the Act, is the mediation disputes can be submitted to mediation. All or certain disputes can be submitted, whether they have arisen or they may arise. That is the dispute which have already arisen or future dispute may arise. So all can be done. And the agreement can also be made prior to the arising of the dispute or subsequent also. So that is the thing. And then it's important that certain number of times there may not be a mediation clause or a mediation agreement, but there can be a reference to some other agreement. Then also there will be a mediation agreement in writing. However, it has to satisfy another ingredient, that to constitute as a mediation agreement, the agreement to reference must be in writing, and the reference must be such in categorical word that they want that to be made as a part of the agreement. So that is the thing. Mediation agreement in the international arbitration can only be for commercial disputes only. So place, I will just skip because it can be anywhere with the mutual consent of the parties, and generally it should be within the territorial jurisdiction of the court. Then section 30 is very important. It talks about online mediation, which will come a little later. Mediation is deemed to have commenced. It provides there is an agreement of the mediation, and one sends a notice to the other parties. The moment it is received, its mediation is said to have commenced. So the timeline will start ticking in, which is presently 120 days, and it can be extended by further 60 days with the mutual consent of the parties. However, if there is no agreement, then the mediation will start from the date of the appointment of the mediator, when the case is of a institutional mediation, or it will be from the consent of the mediator to be appointed, where the parties have agreed to appoint the mediator. So conduct of the mediation will be provided by the regulations, and the regulations will have to be framed by the Mediation Council of India. However, section 15 provides certain broad guidelines that mediator will be required to assist the parties in an independent, neutral, and impartial manner, and be guided by the objectivity and fairness principles. And he can take into account the circumstances of the case. He may take the measures that may be appropriate. He can meet the parties jointly or separately. He is not bound by the principles of CPC and the Indian Evidence Act. That is very, very important. We all know it is not a adversarial process. So that way, language also can be decided. This is all done by the mediator to convene the mediation and to make sure that during the mediation there is an orderly and timely conduct of the mediation and the integrity is maintained. Then there is section 16, which talks about what the mediator has to do. This is very important because this is for the first time in the Act, we are seeing the mediator role, because we have been hearing this in and out, that the mediator has a limited role to play. He has to assist the parties to come to a settlement, but he does not impose the settlement terms. So how he does that mediation, that's a glimpse has been given under section 16, is that in an attempt to resolve the dispute expeditiously, and he has to emphasize categorically that it is the responsibilities of the party to take the decision regarding the claim. However, he will attempt to facilitate the voluntary resolution. He can communicate the views, he can ask the views in a way wherein it's understandable to the parties and the parties are coming to the same page, a better understanding, clarifying the priorities rather than going into the stands. He should be generating the options and should make a conducive atmosphere where the areas of settlement are there. So he just facilitates, he does not impose. That is the main point. And it is very importantly pointed out in the Mediation Act that he cannot act as an arbitrator, representative, or counsel of the party in respect to the matter in which he was the mediator. And similarly, he cannot be called as a witness in any other proceedings also. Timelines have been provided in the Act. It talks about 120 days. And we must note that it is not working days from the date fixed for the first appearance by the mediator. It can be extended by a further period of 60 days. Confidentiality is one most important provision which is there, because we all know mediation is very, very confidential. So all the parties, mediator, mediation service providers, parties, their participants, they all need to keep the things confidential. What all can be kept confidential is provided in the Act by way of acknowledgements, opinions, proposals, apologies, admissions, any kind of thing, and any other mediation communication which is defined in the Act also. Then it talks about clearly that no audio or video recording has to take place when the mediation proceedings are going on, and parties cannot rely whatever has been said in the mediation as an evidence, because otherwise people will not be talking freely in mediation. That is the heart of the mediation. But there are certain exceptions mediator can do for the educational purposes, for training purposes, certain mediation things he can tell the people, but obviously not disclosing the identity of the parties or the particular opinion or the things which may have been discussed. So mediation settlement agreement may be disclosed where it is required for the purposes of registration, enforceability, or challenge. Because when we enforce a particular agreement, obviously it becomes public. When we challenge it, becomes public. When we go for registration, it becomes a public document. Confidentiality may not apply. So then form of the mediation settlement agreement is one of the most important things which this Act talks about, because there is a mediation settlement agreement. It talks about it should be in writing. It can be by all the parties or some of the parties. Disputes can be some or all. But at the end of the day, it has to be signed. It has to be authenticated by the mediator. Terms of the mediation settlement agreement may extend beyond the dispute referred to the mediation. This is very important. Registration is optional. You can do it within 180 days from the date of the authenticated copy of the mediation settlement agreement. Then mediation settlement agreement, where it has to be registered, how it will be done, there will be further regulations which will be made. So we will just move forward. In case of non-settlement report, that is when the mediation has failed or the parties do not want to go ahead, there can be a non-settlement report. So when there is a case of an institutional arbitration, that is the mediation service provider, then mediator has to submit the report to the institutional mediation center who has appointed him. In other cases, that is ad hoc, mediator has to prepare a non-settlement report and provide the signed copy to the parties. It becomes terminated. Irrespective of fact, when the non-settlement report takes place, it can be either when the agreement has not been reached within the 120 plus 60 days, or where the mediator is of the view that no settlement is possible without stating the cause, etc., of the why the mediation was not possible. Deemed termination is also been provided in the Act. It says that on the date of signing of the mediation settlement agreement, if the settlement has happened, then it will be a termination of mediation. If there is a written declaration by the mediator that there is no longer justification of the mediation to happen because the parties have also conveyed their wish, so then that way also termination comes into operation. It can be by way of the communication by the parties where they wish to opt out of the mediation or on the expiry of the time limit. So these are the deemed scenarios where the mediation will come to an end. So the most important part is enforcement. This act talks about that the mediation settlement agreement is final and binding on the parties as well as the persons claiming under them respectively. It can be enforced in accordance with the provisions of the CPC as if it was the judgment or decree passed by the court, similarly to the arbitration award. So then regarding the enforcement, it is very important. It can be relied by parties by way of set off or otherwise in any legal proceedings once a settlement agreement is there. So challenge to the mediation settlement agreement can happen within 90 days from the receipt of the copy of the mediation settlement agreement. However, the court or tribunal on sufficient cause being shown, entertain it within further period of 90 days. The grounds have been provided. The grounds are very limited. It's fraud, corruption, impersonation, or the matters which have been mediated were not fit for mediation, but still they have been mediated. Each one is a separate topic in itself. I'm not touching upon. There are learned speakers. They may be touching upon certain nuances. So then competition of period of limitation for any other proceeding relating to disputes is provided, which says that you need to exclude the time period from the mediation which has commenced and the submission of the non-settlement report or the termination as the case may be. If you want to file a court case, so then the time taken by the parties under this Mediation Act will be excluded. Online mediation is very, very important, but we need to see what the regulation will be framed by the Mediation Council of India, because it talks about that the online mediation, including pre-litigation mediation, may be conducted at any stage. So it can be conducted, but however, we have to make sure that it is integrity-wise, it is sound, because confidentiality should not be breached. So it can be by way of electronic form, it can be by way of computer networks, secure chat rooms, all those things are there. So conduct of online mediation has to make sure that the elements of integrity is very important. If that are compromised, then the online mediation will not be a successful mode. Very important. We need to see how in practice it comes into operation. So that is, so then there is a mediation council. So I will just briefly touch upon that the duties and functions have been provided. They can have an head office in Delhi or at any other place as they be notified by the central government, and can establish offices outside in India also.
We can cut short this.
I can just cut short. I will just on other specific things. So Mediation Council of India role is very important. So they have to make the guidelines for the domestic and international mediation. And then their role is to make sure that they have down the guidelines for the Mediation Institute, mediation service providers, mediators, and other things. You can see on your screen, there are several things which the Mediation Council, who is the authority of this, to make regulations by way of which the provisions will be brought into force. Then there is a mediation service provider, which is the individual mediation centers will be there. So it can be by way of 3-4 centers may be there. It may be a normal body or organization which provide for the conduct of mediation. It can be an authority which is under Legal Services Authorities Act. Court Annex Mediation Center can be there. Any other body. B, C, D are deemed to be mediation service provider recognized. Others will be recognized as per the regulations. Functions of the mediation service provider will be to give accreditation to the mediators. So Act doesn't talk about who can or who cannot be a mediator. So anyone can be a mediator. Obviously, there will be certain regulations, guidelines, norms, how mediators have to be empaneled, including sisters who will be doing these things. Then the providing services of the mediator, providing facilities, secretarial assistance to conduct the mediation. Ethical code of conduct also they will have to do. They will have to facilitate the registration process. The regulations will be made by the Mediation Council of India. So thereafter, mediation institutes are also there. Their main function duties will be provided by the regulations. Presently, the just provide that their main role will be provide training, continuous education, certification of mediators. Mediation Council of India regulations will be made on these things which I have already covered. I am not touching upon here. Then most important thing is mediation settlement, where the government is a party, so they need to take a written consent of their competent authority before they sign. So this is a critical point, because sometimes it may happen the parties, government people who are authorized to attend the mediation, they may say something, and while they go back to their competent authority, that settlement agreement may not be arriving if they do not get the written consent. So this is a thing which is practically required, but we need to see how in practice it will get implemented. Then guidelines can be framed by the government, like we have seen SEBI also and other government institutions. They have their own guidelines for mediation for the disputes wherein they will be involved, so they can be made. Community mediation is a new concept which is provided with the prior mutual consent of the parties. It is for the peace, harmony, and tranquility of the residents of the families. I'm not touching more in detail. I will just say that it's a panel of 3 community mediators, and there is a separate mechanism which is provided. So that is the thing. And last but not the least, then we come to the mediation has an overriding effect irrespective of the fact that the other acts. Second schedule is very important because the Industrial Disputes Act has its own mediation mechanism and other acts are there. So these acts will have their own mediation mechanism. The Mediation Act 2023 will not be applicable. Then the Mediation Act provides for various amendments to the acts wherein the mediation or the word conciliation was there. So to make them in tandem with the Mediation Act, they will be doing this thing. I will not be touching upon. I will just display that you can just see within 1 minute. I will just show that section 28, you can see what is there earlier. Now it provides that wherever the arbitration was there, now mediation has been added. You can see on the right side. Then there is a talks about Arbitration Act. They have made changes by saying that wherever earlier it was written, it's a code of civil procedure. My bad. So when we say code of civil procedure, section 89, when we talk about there, the definition was a little different. Here they have tweaked it and now provided mediation can be mediation, court annex mediation, any other mediation provided by the mediation service provider. So you can see that. Then Legal Service Authority Act, they have tried to make the amendment because earlier the clause talked about negotiation, arbitration, and conciliation. Now the word mediation has also been added. Then there has been amendment to the Arbitration Act, wherein they want to make sure and tell that conciliation word will be treated as mediation now, and you have to be governed by the Mediation Act of 2023. I'm not going into detail. Please forgive me for not going into detail. Micro Small MSME Act also, they have made changes there because there earlier there was conciliation. Now the mediation been inserted and mediation 2023 has been referred. So these all have to come into force and the subsequent amendment will take place if everything goes well accordingly. Then the Companies Act is there for 2. I think there will be speakers who will be touching upon. This is just to highlight that the Mediation Act will be making changes to the Companies Act also, because earlier there was a panel, mediation and conciliation panel was proposed. Now it will be mediation to be conducted as per the Mediation Act. Then 12A Commercial Courts Act also, they have made certain changes. They have provided mediation service provider. They have categorically mentioned Mediation Act at appropriate places. And then Consumer Protection Act is very important because earlier the chapter 5 was there. They have tried to do away with that chapter and they have provided the scheme of mediation, which is in line with the Mediation Act, expressly given that the mediation will be happening under the Mediation Act of 2023. So wherever mediation words were there, they have made corresponding changes to that. So that is the thing. Thank you so much, sir, for patient listening. The act was quite comprehensive. I've tried to cover in shortest possible time. Thank you.
Thank you very much, Vinay. You have extensively covered. I think you have given you have reduced the work of others, so
Yes.
they can focus on more on the aspects of the nitty-gritty of this. So without, thank you, Vinay. You have extensively covered, and the presentation will share to all our participants. Thank you very much.
Thank you, sir. Thank you.
Madam, now Vinay has given you the complete thing.
Yes, he has really given a very extensive, description, analytical approach towards the act. And I think you are rightly saying that we need not go into nitty-gritties of each and every section.
Yeah.
But of course, I would add to what even Mr. Mohit Mathur, as the president of our bar, said, that it is a game changer, where sometimes even our honorable judges feel that there are issues relating to relationships or there are complex issues. The matters have been forwarded towards the mediation center to find out resolution to their complex issues. So it is a game changer. And for resolution of corporate disputes, I will say for all types of disputes where there are relationships, whether there are personal, organizational, professional, or business relationships. I'll just like to say in general that investment and trade are 2 drivers of the economic growth. And both of these issues, human beings are involved in this. Wherever there are human beings involved, there are bound to be conflicts. So in courts, we get to know the disputes. But why the dispute has arisen, only mediation tells us. Because of the difference of opinion, difference in thoughts, difference in process. So we enter into many conflicts. Post-colonial era, the disputes have been referred for resolution to our courts system. And the number is boundless. But to attain impressive economic growth, there is a necessity to realign this dispute resolution system and bring it basically towards conflict management ecosystem. So with a view to develop business and investment friendly jurisdiction, we need avenues for diffusing conflicts and not escalating conflicts. In the judicial process, the conflicts escalates. The moment a judgment comes, there is a one winner, a one loser. And sometimes even the winner is a loser at the end in terms of money, cost, and energy. So what is important is that in the adjudicatory process, the warring parties look at each other as enemies. And after long drawn battle, the winner feels that even I have lost, if not money, but maybe relationship and other aspects which are important to human beings. Let us just understand what mediation is. Actually, mediation has been an integral part of our conflict resolution system. We look at Mahabharata. Lord Krishna went to Kauravas and asked for 5 grams. 5 ग्राम दे दो, तो ये जो महाभारत का युद्ध हुआ, आज शायद वो युद्ध का इफेक्ट हमारे महाभारत में उस तरीके से नहीं डिस्क्राइब होता. Similarly, panchayats, the panchs are there who have been helping people to resolve their issues, our elders. But what has been happening so far in these type of system was the decision was being made by others. Elders used to decide what is right, what is wrong. Panch used to decide, follow this. So that's the rule. But mediation was basically introduced in our legal system to reduce the burden initially, of course, in 2002 by an amendment. But over a period of time, what has been understood by us is that this is not only an alternative to the dispute redressal mechanism. In fact, it is an appropriate dispute redressal mechanism. Why and how? Wherever the parties feel that their efforts to negotiate themselves have failed, they can always come and seek assisted negotiation. This assisted negotiation is mediation. And this is provided by whom? A trained mediator. A trained mediator who knows the skills of communication and negotiation techniques. He helps the parties to look at their interests and come out of their positions. In courts, the parties dig into their positions. They take strong position, and sometimes it becomes difficult even for the judges to decide who is wrong. Both of them appear to be wrong, right, or both of them may appear to them to be wrong, but they decide based on precedents. So what happens in mediation? The mediator brings the parties to negotiated settlements. They look at their present, they look at their needs, they look at their interests. So this is a qualification which is available with a trained mediator. It is a process which allows the parties to look at their present and not at past. In this world of consumer satisfaction, I will say that even our judicial system, people look at us as service providers. How we are service providers? Because if somebody wants justice today, in this long drawn battle provided so far, the justice will be seen somewhere in future. In some cases, it is seen even, you can say, generations go through this process, not only from the point of view of the party, sometimes even generations from the point of view of the lawyers also. And the results are still not seen. So in that, now what has happened is mediator plays an important role in shepherding the conflicting parties towards settlement, whereby everyone walks away satisfied. Now, various high-profile cases involving the business and family both have been decided through mediation. This helps in recovery of business quickly and gives the conflicting parties an opportunity to be a family again. In the judicial process, the parties are no more a family, even if there is a winner. It provides a situation of win-win. Let us now just giving example, while maintaining confidentiality, I can say the giant companies like Apple, Amazon, they have started including mediation as a clause in their contracts for finding solution, as it was being happened earlier in arbitration cases. So there has to be, like Vinayji has given all those important issues relating to how the clause has to be incorporated. Earlier, it was only with regard to arbitration, but now people have started having, even before the coming into force of this act, people had started including a clause for mediation. Now, this is a process which works into the stage of execution. The beauty of mediation is what happens in courts. A decree is passed. After that, the next process starts, and that is execution. This process of mediation not only helps the parties to find out a solution, but they also talk about the execution part. So execution proceedings which happen in court separately, they are taken care of in the mediated settlement itself. Suppose, for an example, there is an agreement that this much amount will be paid by A to B. How this amount will be paid, when this amount will be paid, what if the amount is not paid, all those things are sorted out. So this is a one composite settlement which helps the parties to resolve their issues for future as well. Now, by coming into force of this act, what I feel, what has been done for the last more than 16 years without the legislation is being endorsed. Overall, broadly, most of the things are favorably touched upon in the act. Like, for example, taking about online mediation. COVID taught us to shift from physical mediation to online mediation. During that time, mediation reached everybody's home wherever we found conflict. So online mediation, once experienced, I as an organizing secretary of Samadhan can endorse that confidentiality, though becomes a little doubtful, but by a trained, well-equipped mediator, this part can also be taken care of in online mediation. And results are absolutely satisfactory so far. In our system, whenever somebody logs into their phones or laptops, first they give an undertaking that they will maintain confidentiality. So a trained and a qualified mediator can control the breaking of rules of confidentiality. Bringing into community mediation. We all are looking at a peaceful community. There are many issues which were not touched upon initially, even before the act coming into position. But now, even we are looking at a community, and there has been a system has been provided in the act. You know, signing of the convention took place in 2017. Since then, we had been struggling to get this legislation. It was first presented, I think, before the Rajya Sabha in the year 2017. And then a parliamentary committee was appointed to look at certain aspects. As Mr. Mohit Mathur had pointed out, of course, the criminal matters, which are non-compoundable, are out of the purview of this act. A very big concern of all of us is with regard to this. But I'm sure wherever there are some imperfections in this act, our judicial system, our honorable courts will come to our rescue and will make it perfect. As he gave an example of matrimonial disputes, most of the matrimonial disputes are referred even at pre-litigation stage to Samadhan. Parties sit together, they find out a solution to their problem themselves. In court-annexed mediation centers, you will find the bulk is for matrimonial matters. Rather, at one stage, people thought that mediation works only in matrimonial or family issues. So 1/3 of most of the centers you will find is relating to matrimonial issues. In court-annexed mediation centers, we generally find that one or the two minimum FIRs are also registered there. Now, a big question mark is there. What will happen to those matters? Will they be referred? And if there is a settlement, will the court analyze that from the purview of the act, or they will follow the judgments like Gyan Singh, Lakshmi Narayan, etc., and how the things will go further? And we are very hopeful our legal system will definitely help us on these issues. So let me just tell you one thing more, particularly from corporate sector point of view. Earlier, the mediation centers were opened with court-annexed buildings, or they were annexed to the court. And mostly lawyers have been trained so far. But this Mediation Act has basically enlarged the umbrella. And anybody can be trained as a mediator. So that's the beauty of this act now, that anybody who is outside the legal system can also be a mediator. For that, you need a training. Definitely, the council will bring up the rules who all can be the mediators. But one very big aspect which I feel this act can help us. So far, only legal people, that is lawyers, have been mediating so far. And if we see an aspect where there is something relating to accounting, something relating to construction, something specific, maybe even medical. So whenever there are those issues, by only expertise in the process, we found it very difficult to proceed ahead, because mediation, the process basically brings you to resolution if you use your questioning skills. Mediator is not supposed to decide for the parties. Mediator is not supposed to advise the parties. Mediator has a very specific skill, asking the right question at the right time to the parties to get them to resolution. That is possible only if you have the domain knowledge as such. I'm not asking or expecting domain expertise, but domain knowledge is must. I put myself into the shoes of a chartered accountant like you. If there is any issue with regard to accountancy, I always say, ask your chartered accountant. Ask your accountants, ask the expert people in this field. So now I think the area of mediation will get enlarged, where specifically trained mediators in specific fields will be available in the market as per the guidelines and the rules which will be provided by the council. And people will look forward to have their resolution tailor-made, which suits them from the purview of the parties, which will be possible to have more issues resolved through the process of mediation. And one thing more aspect I just want to tell, because Mr. Mohit Mathur had pointed out that mediation works for everyone, but for lawyers. I totally disagree with this also. It doesn't affect our pocket adversely. Initially, it was that it is not ADR, that is alternative dispute redressal mechanism. It was considered as alarming drop in revenue for lawyers. It's not so. In today's time, when a client comes to a lawyer's office, he's looking for justice today. It is for the lawyer to decide whether this matter is fit for litigation, fit for arbitration, or fit for mediation. And if a lawyer is taking the parties towards the route of mediation, he can very well charge his fee for appearance before the mediator, for his participation in the process of mediation, and also in drafting of settlement. And I want to inform everybody that clients these days get reference for such type of clients, get more references to such lawyers. And there is no alarming drop in revenue. Rather, there is an alarming increase in the revenue of lawyers in such type of fields. So Act provides for most of the things. What I feel that now, since the government has also been included, of course, there are certain process has been described in the Act itself. Still, I feel it's a big game changer. And with the help of our judicial system, wherever we find some lacunas, it is going to be a game changer, a less time-consuming, cost-effective, and beneficial to the parties, a process being looked at for the benefit of the larger society, and the mediators will be looked upon as peacemakers in the society. I think, thank you, Vinayji, Pawanji.
Thank you. Thank you.
Any questions I'll take up.
Thank you. Thank you, madam. You have rightly pointing out, and the reference of Mahabharata is a right apt, that it was a first mediation by Lord Krishna. And the way you have a experience in this area, the point which you have covered is really very good. And I will definitely, because after Amit ji and Ravi, we will have a question answer. So there are so many questions with me. We want to ask and we want to clarify what Vinay has shown and what you have mentioned. So now I will request Amit Khemka ji to please, with your experience in the corporate world, the way you are handling various legal and corporate cases, what is your take on this subject?
Good evening, everybody. Good evening, Veena ma'am. Good evening, Pavanji, and thank you everyone for allowing me to be part of it. Actually, I am not in my formals because I am right now on vacation. So excuse me for not being in formals. You know, what Veena ji did not say, I'll start from there. Initially, it was considered that any kind of mediation process will actually be against the profession. And there was a group of individuals, including Madam Veena Ralli, headed by people like Mr. A.S. Chandok, and so on. There are lots of names in that, who thought that as lawyers, we have taken a lot from the profession. And as mediators, we want to give back to the profession. And how to give back? We are all blamed for the whole system, including the judges, lawyers, police people, establishments. We are all blamed for delays in dispensation of justice. These were the pioneers who had broken this myth. They saw to it that the profession itself facilitates justice by adopting this wonderful medium of mediation. We were talking of revenues. Pavanji, one of the most important revenue for a professional is that he gets a relief to his client. That is the biggest revenue for him. Now, that revenue has not been coming to us. Maybe we were getting in monetary terms, but still the frustration, we were facing the frustration of the client, frustration of the people, that they were not getting the relief from the court in spite of sometimes having very good cases. Now, this whole thing, which started about 17 years ago, has changed the complete complexion of the dispute resolution mechanism. And what this act probably wants to do, as Veena ji rightly said, is to provide legitimacy to this effort of the professionals. And what this act probably wants to achieve is to try to tell other professionals like company secretaries, chartered accountants, and others that, look, what the people from legal profession have done is so wonderful, and you all are also required. And that would be the real, that would be the actual real achievement of this law. There are no doubts that I have so many question marks in this act. Take, for example, a council has been created. And there seems to be no representation of these pillars of mediation in the council. Everyone has to be nominated by the government. While the fact is that there have been numerous judges in Supreme Court and different high courts, there have been numerous lawyers who have done so tremendously for the process of mediation to get legitimized in this country, that they breathe, they eat, they drink mediation. How can you have a council without them? I'm very sure that this is the first step. The government will relook at the things. Without these people who have trained thousands of mediators across the country, they are in continuous process of training. When I was going through the act, what I found was that lots and lots of things which were taught to us during training by these I would say these pillars of mediation were just repeated in the act. So in that sense, it is legitimizing it. But at places, it falls short in certain ways. For example, the training. What I would have expected is to institutionalize the training. Because let me tell you how important the training is. As lawyers with decades of professional experience behind us, and with a large number of settlements having been arrived on our table, we start believing, we all professionals start believing that we are born negotiators, we are born mediators. And we can do it. We are very good at it. We did hundreds of them. But sir, when I went for training as a mediator, after I came back from that training, I realized I knew nothing about the process of mediation. I knew nothing about the negotiation skill. And another thing, that we as lawyers are taught to be aggressive, because we are, after all, in an adversarial profession, where we don't let others talk. At times, we would try to snub. But as mediators, it is the role reversal. Here we are the people who hear, who listen, who are patient, who are not aggressive. So the training of a mediator is a very, very important aspect. And for that, I would expect this act to institutionalize that training a little more than words. Then Mohit touched one very important aspect, and that was that after all, what are we looking at with mediation? What are we trying to achieve? To my mind, we are trying to achieve justice. Now, can you compartmentalize the justice even when the justice is coming by way, even when the justice is coming by way of a party mandated justice? Mediation is something where the parties decide their own case. So, how can you say that no, in this process, criminal cases will not be decided, or the cases which are non-compoundable will not be decided? So I ought to agree with Mohit ji that this field has to be left open. When we give our opening statement as trained mediators to the parties, we often say that, look, you might have come to us for one dispute, but if there are other disputes between you, even those could be put on table. And we would want you to go back home with all your disputes inter se having been settled. Now, how can it be that you say that, okay, your civil disputes will be settled, your compoundable criminal disputes will be settled, but your non-compoundable criminal disputes will not be settled? So we have to leave it ultimately to the discretion of the court. Otherwise, don't give power under 482 to the High Court or to the Supreme Court on those discretionary powers or inherent powers. The purpose is to provide ultimate justice. Now, I would certainly say that it is a very, very big, very, very great beginning. As Veena ma'am said, that the purpose seems to be to put legitimacy, to recognize what has been done in the last 17 years. One. Second, to bring in more and more disputes, even from the diverse fields, into the net. Try to train more professionals from other professions as well as mediators. And that has to be taken as salutary, that has to be welcomed. And I feel that this is the time for company secretaries especially, because chartered accountants normally are not part of any dispute where there are two parties involved. But the company secretaries, just like lawyers, have disputes in their, where they might be involved, because there may be two parties. It could be the directors inter se, it could be company fighting with some other company, or other disputes could be there. So in those situations also, now it is, I think, a very important juncture for the company secretaries as well to start training themselves as mediators. So, and I'm very hopeful, and I'm sure that Company Secretaries Institute, being a very proactive institute, will certainly take it up very quickly and start training the mediators. But as I said, it ought to be institutionalized, and people who have really turned the tables need to be the people who will train, who will really be the pillars of this whole system, because it requires lots of enthusiasm, lots of spirit, lots of, they really want to do it, and you can see it comes from their personality. So I feel that at one hand it is a very welcome step. On the other hand, it is a first step, if I may say so, from the legislature. So, and very soon you will see certain amendments in it. I am 100% sure about it. And there would be lots of inputs coming from the business community, professional community. But at the end of the day, it will be fantastic for the business communities, for corporate people, and for normal litigants. Thank you, Pavanji. Thank you very much.
Thank you, Amitji. Despite of you are on holiday, I know you have come. Thank you very much. And with your experience, the wisdom you have shared, and it is reflecting that this is the future. So our last speaker is Ravi. Ravi, please explain your point of view, because you do the corporate litigation work and you work in the corporate. So what is your take on this?
Certainly, sir. Thank you, everyone. I think the eminent speakers and panelists have given a great deal of knowledge on what is the concept of mediation and how it is going to help. I must start by conceding first that I only while preparing to understand and gain insight on this law, I figured out that the concept was fairly underdogged. And then in the course of research, I came across data on mediation already done in form of the data put in before Lok Sabha, where it has been recorded year on year how many mediations were referred and how many were settled. I'll just tell you very quickly, starting from 2018-19, more than, on an average, if you see, more than 3 lakhs cases across India were received. And the number of cases being settled over the years have only increased. The concept is itself fairly old, nearly 2 decades, when in 2002 or around that time, Section 89 was introduced. Thereafter, it was challenged and constitutional validity was upheld in the case of Salem Bar Association. Later on came AFCON's case, whereby Supreme Court further directed that the disputes can be resolved through mediation. And there have been catena of judgments through which this law and the practice has evolved. Kinkar also mentioned about the training, the specialized training that is being imparted on the subject, on this particular aspect of dispute resolution. Veena ma'am, I think, appropriately mentioned that instead of alternate, it is the appropriate dispute resolution method. And Mr. Mohit Mathur highlighted what are the fetters that should be removed going forward. Now, this law finds its genesis out of Singapore Convention, which is akin to New York Convention that gave genesis to arbitration law as we see today in India. Not starting with the criticism, the points which require a redo or a reconsideration in the law, I'll start with the focus of today's program, that is on the corporate side. But let me give a brief background. Even the Ayodhya dispute, the Ram Mandir dispute, was under mediation. It's a common knowledge. Apart from it, I found out that across the world, even business disputes, if you start with India, see the disputes between Ambani brothers. That was resolved through mediation, an informal mediation, where their mother played a big role. Because in India, you have plurality of mediators, family members, and it has been recognized by Law Commission as well. So that's an acceptable practice of mediating. Thereafter, if you see South African telecom major MTN's case and the disputes between Cipla and Glenmark, all of those were resolved through mediation. So it is not in this MTN or Cipla versus Glenmark, these were not disputes of ordinary commercial nature. This was a takeover dispute and fairly cross-border. So this reflects on the capacity or the potential that this process of mediation has on resolving the disputes thoroughly and effectively. Now, in Indian landscape, the work on mediation so far, before this law was introduced, can at best be called a patchwork, because although substantive or the concept was fairly recognized, the procedural aspect of it and the nuances were not laid down in form of a statute. There were principles, there were guidelines, there were rules also starting from 2003 and 2005, and there were various committee reports. But this piece of legislation, I feel, takes all the patchworks in light of the Singapore Convention and weaves it together. And as rightly stated by Khemka sir, it is in fact the fruits of the industriousness of the torch bearers like Veena ma'am and others that Khemka sir mentioned, and the list is fairly long as he rightly mentioned. It is the fruit of these people that this law, the need of this law was recognized, and now it is going to be implemented. If you analyze it closely, what this law will change is the idea of looking at disputes and their resolution. And I think that is fairly cultural change rather than a change of ordinary nature. To know that the only remedy to resolve a dispute is not the adversarial way, but also a non-adversarial way where you do not need an adjudicator, an independent arbiter, but a facilitator who would act as a conduit for clear, transparent, and meaningful communications is in itself a very effective way to start with. And these are all the terms defined in the law. As Savine elucidated that the role of mediator is also given in the law itself. But that role is perhaps very broad. And I think success of this law is into the skills honed by the mediators and professionals, which I think Khemka sir very beautifully explained that although we tend to feel that we can negotiate or persuade people, he himself, and although he's a master of negotiations and articulation, but he himself found himself to have seen a lot under the training, and he gained a lot of insights through it. So therefore, the success of this law will depend on what kind of skills are honed by the professionals who are going to mediate the differences. A skilled mediator may turn a very complex dispute, which is simple, but couched in extreme complexities and egos of the parties. He may crack it and he may resolve it. And an unskilled mediator may ruin it for all time to come and put it into the rigmarole of ruinous litigation. So therefore, that's one. But now coming back to the corporate or commercial aspect of the impact of this law on the commercial and corporate disputes. If you see the thematic expression under this entire act and the focus is also on the commercial disputes, where when they have defined the mediation and the mediating parties, they have included the government, any disputes with government in relation to commercial disputes. So you already see that the focus is to bring commercial disputes into the ambit of this law with certain focus, and particularly with government entities. Now, it is for us to see that whether in those disputes going forward, how the government and the private parties will avail the remedies under this law, and whether at all a culture will develop or not to evaluate the platform of mediation when an already successful platform of arbitration is there. But the experience with arbitration, although net result is positive, but it also has become costly, and the lacuna of delays are also there. So therefore, this mediation law is not only for commercial disputes which arise out of simple, ordinary commercial contracts, but these could be evaluated for disputes pertaining to valuations, disputes between shareholders, interstate disputes, directorial disputes, or disputes between two companies, as well as the intra-company disputes, so far as they are not excluded specifically on the grounds of public policy. And I think the principles of non-arbitrability, as expounded in the case of Vidya Brolia, would also, to a fair extent, so far as it is consistent with the Schedule 1 of this Mediation Act, would be helpful in determining what can be mediated or not. But currently, because the exclusions are specified in the schedule, the only thing one needs to see is that if the subject matter of a dispute is falling clearly under the exclusion, then only parties should shy away from mediating, else it is certainly worth trying. And the scope of mediation, I'm not talking about criminal cases, that's a different word altogether, but apart from the criminal matters, largely because these disputes largely arise in commercial domain and corporate domain, therefore all those disputes can be rekindled, or those can be resolved and at least attempted to be resolved through mediation. In fact, Section 442 of Companies Act already provides for a mediation and conciliation panel ever since the act was brought into existence. But that remained a non-starter, because even though a panel of mediator is maintained by regional directors and references were made ad hoc, because the discretion was with NCLT to refer the matters, but because of lack of an interactive website or a database, or lack of reports being published regularly to showcase the efficacy of this entire mechanism, it resulted into this particular forum in this particular platform being underdog, and it somehow a perception developed that it is rather not a fruitful exercise to do, because you don't have any control over it. Ultimately, every dispute, or I would start with this, that every commercial transaction is premised on good faith. Without good faith, there could be no commerce, no trade. And the mediation restores it through facilitation, through transparent communications. And this is essentially a process which runs on the without prejudice principle. And the principle is itself of a privilege, although it has its own limitations, as also recognized in India. But the body of law is more stronger in UK and Singapore. But those legitimate exceptions, as well as the application of these principles, are in fact embedded in the mediation law. So it is not that if you participate in mediation, whatever is discussed can be used in evidence if the mediation fails. A lot of times this is also fear between parties. So I think to start with, it's a very, very good law. It has been legislated finally. And going forward, a culture needs to be invoked that people go for it, people try it. And only by experimenting with this law more and more, we would know how it evolves, and we would see its practical utility. And so far as practical utility is concerned, I already referred to the data published by Lok Sabha, and it shows that it is fairly it's fairly efficacious. So that's all from my side, sir. The takeaway is that it is not only for some petty disputes. If the global multinational players can resolve their disputes through mediation, I think it's only a matter of mindset and rearing a culture that people try it and resolve their dispute going forward.
Okay. Thank you, Ravi. Thank you very much for giving this. So now time for question answer session. We have received various questions. So I will ask one by one from my all panelists. Okay, Madam, does the law makes it mandatory to first go for mediation, and if no resolution, then seek court intervention?
No, sir, it has now, earlier when it was proposed in 2017, it was like that, but now it is not exactly like that, except under the Commercial Courts Act. You may go for mediation and you may not go. But of course, for commercial matters, or if you are covered by the Commercial Courts Act, then definitely you have to follow the process. You have first to approach the mediation, and that also to Delhi State Legal Services Authorities as envisaged under the said Act. The only benefit now we have got under the Commercial Courts Act, earlier the time was 6 months, earlier the time was 6 months plus 2 months. Now it is 120 days and 60 days. So now total time which can be excluded from the period of limitation is 180 days. So this is how little change has come, but otherwise it is still voluntary. And I must tell you, even under the Commercial Court Act, though it is mandatory, but voluntariness has not been taken away from the parties. They may or they may not participate in the process of mediation.
Okay. Vinay, does it prevail over other act, and in which situation?
Sir, there is a overriding effect of this Mediation Act, like Schedule 2 or 3. I think there are a list of acts which are given, like Industrial Disputes Act and Sexual Harassment Act, and other acts are there where they have their own mediation mechanisms available. So they are not touched upon. Obviously, they will be excluded, sir. So apart from that, everything is covered voluntarily. It can be made part of it.
Okay.
May I just add something here?
Yeah, please.
In earlier, actually, in various legislation, somewhere the word conciliation has been used and somewhere the word mediation has been used.
Yeah.
To avoid that controversy, to avoid that confusion now, this act, Mediation Act, will prevail. So there is no conciliation and mediation, two things separately. It is only mediation as per the act. So that is also the benefit as per Schedule 2 annexed to the Mediation Act.
So we can presume that conciliation word is the conciliation word is no longer
is available to us. Even under the Arbitration and Conciliation Act, it has been considered because the schedule has been attached to that also.
Sir, there is one more point. There are various schedules which I just showed in my slides also. Arbitration Act, like Commercial Courts Act, MSME Act, and Contract Act. Wherever the conciliation words are there, they have replaced it with mediation. And they have specifically said that wherever conciliation will be happening, it will be mediation as per the Mediation Act 2023.
Okay.
Thank you.
How the Arbitration Act differ from Mediation Act, and what opportunity are available for CA and CS? Because they are working in corporate world.
See, the thing is that as I said, that it is a doing of lawyers, basically, the mediation. So till now, there is an impression that only lawyers can be and should be the mediators. And to a very large extent, I would say that it is the legal knowledge comes very handy. But at the same time, there could be cases where, apart from legal knowledge, there could be the knowledge of other laws and other aspects of life is required. So this law recognizes that aspect and recognizes that people from other professions, people who may not be professionals, may also be, in an appropriate case, could be good mediators. So, but as I said, that training ought to be imparted in all these cases, and without training, it could actually be counterproductive, because training is such an important thing in this whole process that the utility of that training cannot be ignored. Pavanji, I have a question from Beena ma'am, actually, so I'll just like to put that. Okay. Now, question is that the new law says that the process will get terminated after 120 days or at best after 180 days. Now, does it mean a new, if the process requires further extension, if the mediator and the parties think that there is a requirement of continuation of that process, would it mean a fresh mediation process will have to be started? Or what would be, I don't find a solution to
Any
that.
answer to the answer? There is no answer in the Act, Abhijit, very
Yes.
well analyzed by you.
Yes.
But there is a practical aspect attached to this. Suppose there is a mediation which has extended beyond this period and there is a settlement to that. Generally, parties agree when they ultimately decide themselves, yes, we have agreed, we do not want to go ahead. And what our experience, and you also as a senior trained mediator of Samadhan, you also have experienced many a times, that animosity is reduced absolutely. And parties, only 1% cases will be left for courts to be decided where settlement has taken place or it has not taken place. So for that 1% cases, of course, the limitation period will not be extended if I read it correctly. But otherwise, if the parties are extended themselves, law does not recognize this. But if they are voluntarily, like as per Delhi High Court rules now, it is 90 days to be extended further only by 30 days. So for what was happening in court annexed mediation centers, we were seeking orders from the court because court has power to extend the period. In individual cases where pre-litigation matters are pending, parties were extending with consent. So this gray area, if there is no dispute in the settlement, maybe we don't need any further thing. But whenever there is an issue, that issue will be beyond the scope of the courts to be considered if it is beyond that period. So let's see how the legislation helps us further on this.
The problem arises, take an example where we are called upon in a mediation to actually deliberate on mode of partition. Right. It cannot be decided in 120 days.
Yes.
There is lot of thing which has to be done, and sometimes we actually get things executed during the mediation process.
Yes.
So though that execution itself takes away a lot of time. So you are actually not deliberating over what is the mediation or what is the settlement, but you want, yes.
Amitji, here I will add one thing. So far, most of the people are doing ad hoc mediation. We are mainly lawyers practicing in the field of legal field and then doing mediation simultaneously. But under this act, now we are looking at full-fledged professional mediators. They sit over the days together if we see at international level mediation. So we are also preparing ourselves for such type of mediations where we conclude the proceedings at the earliest and we do not extend and defer the dates, and like in courts, come after 15 days, you will take 15 days. Okay, I need 10 days. Nothing like that. People have to come prepared for mediation if we want to compete with mediators at international level. So I think we'll be able to do that. We take it as a profession.
Okay.
Thank you.
It's because now I have to bombard questions to you. It's complete 180 days or actual time taken by mediation, which will be excluded from limitation period.
So, sir, 180 days completely, because once we seek even for extension, then the complete period will be eliminated from that.
Okay.
If we read the section, it says 120 days and it can be the parties for mediation may be extended for a further period as agreed by the parties, but not exceeding 60 days. So complete 180 days.
Okay. In a commercial dispute, when there are several parties and one of the parties residing outside in transaction or international, shall be mediated in India. Is territorial jurisdiction seat of mediation works like arbitration in the future?
So the act says wherever the mediator is, it doesn't make, because jurisdiction otherwise has to be from the legal purview. Wherever the mediator is sitting, even online mediation is taking place. So it will be implemented and executed as per the territorial jurisdiction or pecuniary jurisdiction, whatever is applicable in that situation. Even if the parties decide for outside the jurisdiction, but execution has to take place wherever the jurisdiction is.
Okay, very interesting, a very layman question, but very interesting at this moment. A broad way, how mediation is different from arbitration? Why need of this new law?
Sir, that is the basic thing, I think. I'll just say 2 lines. A judge decides for the parties.
Yeah.
So does the arbitrator decides for the parties.
Okay.
The only difference is the process is little flexible in arbitration as per the Arbitration Act. But who is the decision maker? The decision maker is the adjudicator, whether he's a judge or he's an arbitrator appointed by the parties themselves. In mediation, The decision flows from the parties themselves. They are empowered to take decision for themselves. They are facilitated to arrive at amicable resolution. If I am empowered, if it is my decision, I have to agree to that. I implement that. Otherwise, objections under Section 34 will be languishing in court for a good number of years also. But here I see only 1% matters going back to court, where parties may say, as per the provisions applicable, that either there is corruption or impersonation or something like that. So challenge is less. So it really helps. Two things. It helps in decision-making process being final, getting finality, and it also helps in building up relationships, which even arbitration doesn't do.
And the control over outcome is also there.
That's what I'm saying,
That's
that
right.
the outcome is in the hands of the parties themselves. They are the decision makers.
There are no appeals.
Yes.
Pawanji, there are no appeals.
Hmm.
And as Veena ma'am said, that people go back after hugging each other. That is the beauty of mediation.
And then
People who are
cost
not
is
even
also-
talking to. Yeah.
And cost is also reduced, confidentiality is maintained.
So
formality-
finality also comes at the first stage itself. That pre-litigation stage, you get the finality.
Pawanji,
Otherwise
I'll just take 1 minute and give you one incident. In one of the cases which I was the mediator, one of the parties gave me a slip of paper. There was something written on that. And after the mediation failed, that party went and asked the court that I had given that paper to the mediator, so summon it. I went to Veena ma'am and said that the court cannot summon it. What did she write to the court? She wrote to the court that you have no authority to summon it. So this is the beauty of mediation.
Yeah.
Which other process you can have this level of confidentiality.
Okay.
So on my behalf, she said, no, you will not write. I will write as the secretary of the mediation center. So this is the whole beauty of the thing.
Okay. Vinay, what is who can be eligible for mediator? Anybody?
Yes, sir.
Anybody.
Anybody can become a mediator. Probably in the ADR mechanism, government is thinking aloud, and that is rightly so also. Even in arbitration also, company secretaries, even my erstwhile tenure of the registrar at Indian Council of Arbitration also, I have appointed company secretary also as arbitrator. And presently, India International Arbitration Center, constituted under an act of parliament and is of national importance, we have empaneled arbitrators. The window is open, and therein we are seeing there are so many professionals from chartered accountants and company secretaries. They are applying, and going forward, once the regulations of Mediation Council of India are in place and the mediation service provided, it is one of our mandates also under our India International Arbitration Center Act that we have to do mediation. So there will be panel of mediators. There also everyone will be eligible, including the company secretaries.
Madam, you are not seeing a future that because all these mediation, you require experts. And
Yes.
all these technical points, when we are saying corporate law will come, so now the issues related to merger, where valuation is the issue, there are some other issues, there are partners issue, two shareholders are fighting to each other. But all these things require some expertise knowledge. So do you
Yes.
think CA and CS will be a future mediator, easily available, that will be a game changer for them also as a mediator?
Pawanji, I initially in my presentation, I also said that domain knowledge is very important even for the mediation process. And domain knowledge comes from the expert in the particular field. I may be a lawyer, but I may not be knowing about the construction law. I might not be knowing about the medical facilities. So all those things now will be possible for me to be looked upon in a particular matter if I have an expert with me. But here I would like to express one thing, which is my concern as an organizing secretary also. We have to be trained completely with the process of mediation. As pointed out even by Vinayji, the process of mediation is one thing. The process of co-mediation is another thing. So maybe a lawyer expert in the legal field who, because as even pointed out by Amitji, that it adds on to the value of the process of mediation if you are a lawyer. So you will understand how to end the resolution, how to write the resolution, how to write the settlements, but with the help of an expert who is expert in the subject involved in the process. So people must be taught about co-mediation as well, as we see in division bench, courts holding that sometimes we don't even know what is transpiring in their minds, but there has to be a full-fledged session on co-mediation to be taught to the people who come forward for mediation training. And I think we should not take it like this, that 40 hours training is enough. There is a lot to be understood with regard to this process. There is a lot to be absorbed in this process, and that comes from experience as well. So we should be open to learning, because that will make us improve our credentials as mediators.
And what is
Pavanji, let me just add few things to this. After the 40-hour training, people with decades of experience behind them were asked to be co-mediators in at least 20 cases in Samadhan, with even people junior to them. Okay, because they knew it, they were the ones who had the experience of it.
Okay.
And what is very important is, as she rightly said, drafting of the settlement. You may arrive at a settlement, but you may draft a settlement which will ultimately give rise to another dispute. So that is also very important, and that is why the domain knowledge is required. Thank you, sir.
Madam, what is the fee of mediator?
Very important question. Sir, I'll just say that so far, mediation has not been seen by the parties also as a profession, because they have been diverted from one courtroom, one part of the building, to another part of the building. And people feel that since mediator is not carrying any heavy files in his or her hand, means the efforts are not important. Our system has not acknowledged the fee part so far, but I'm sure if we prepare ourselves as full-time professionals in the process of mediation, people will have to acknowledge our efforts, and they will reward the mediators involved in a particular way. That's the way they deserve their services to be rewarded. And I'm sure very soon, after the notification coming into force, things will change, and after particularly the council passing some rules on this. We are hopeful, but so far it has not been very encouraging for the mediators. As Mitiji said, that it was taken as we are paying back to the society what we got from the profession.
One question.
What will happen to the youngsters then?
With government officers being in the council, with government officers being in the council, what are you expecting? I don't know really.
No expectations. That's what
that is the worst part of this whole act.
Yes, because it was. Sorry, Amiji, started as a free service to the parties. So far we have not been able to.
We are good enough doing it pro bono, but let somebody who can't feel for it not decide about how we are to be.
Absolutely right. I endorse your views on this.
Yes,
Madam,
they can't feel for it.
Have you witnessed cases where arbitration failed, where mediation succeeded?
Sir, I will rather say it in a different way. In our High Court, in most of the cases, wherever somebody is approaching court for appointment of an arbitrator, the courts are referring for mediations first. And they are still giving some time in the beginning to try mediation and then start arbitration. Even ad hoc mediators are sending their matters for mediation. So we are working on such matters and sending the mediation settlements here for passing of consent awards. And of course, wherever arbitration has failed, mediation has still worked, as the autonomy of the parties, the self-determination of the parties has empowered them to take decisions for themselves. It has been really encouraging to see the results in mediation.
And Pavanji, there are n number of cases where first round failed, it went back to the court, second round failed, it went back to the court, in third round, mediation succeeded. So there is no stage when it cannot succeed, and there is no proceeding where it cannot succeed.
Okay, madam, any examination or training program for the mediator under this act? What is the eligibility criteria or qualification?
Nothing so far in the act, sir. We are still looking for it.
Okay. So the enforceability of settlement agreement in court and appeal, where to lie?
Sir, this will be as per the jurisdiction, I believe, that is whether pecuniary or territorial jurisdiction, so far as we read in between the lines of the act. So let's see, because it's not appeal. Basically, we can just challenge the award to the limited grounds provided under the act. And I think it will be subject to the involvement of the subject in a particular matter.
Somebody is asking how to apply for mediator and where.
Again, a gray area, sir, because so far we are governed by our rules of every high court. Delhi High Court provides for 10 years standing and appointment of a mediator by Delhi High Court. The standing has to be 10 years and then a training. And as Amitji said, as per our rules, even co-mediation for a practical training and then again training, then a person is appointed as a mediator. Under the Mediation and Conciliation Project Committee appointed as per the Supreme Court, various mediators have been trained and they are attached to various district courts and also to the Supreme Court. Many trainings are taking place, sir, so far. But where is the work? We are still not in a position to find an answer under the said act. So we will wait who are going to be identified as service providers, who are going to be identified to give trainings. So then we will see whether those people will be appointed as mediators in pre-litigation mediation matters or not. We have yet to see the results.
So the question before that would be what training?
Okay.
Who is going to specify what training?
Madam, last question, where mediation award will be implemented?
Sir, it will be implemented as per the jurisdiction.
Okay.
Even
As a
if
court
people,
decree.
as a wherever the jurisdiction is possible, even if you deviate for the process to be taking place at a different place, but still the execution as per the act, the execution of the settlement will be as per the jurisdiction.
So thank you very much. Thank you. Thanks all my panelists, those who have joined this, and thank you, Beena Madam, and thank you, Vinay, for this.
Thank you so much, sir, for giving me an opportunity.
But as a traditional, what we are doing at last, we are summarizing this topic and asking the success of this particular concept. So I'll start with Ravi. Ravi, what is your take on this entire thing?
I think a thorough legislation, good start, but we need more cultural change and push from all the corners, even from judiciary, to see it a practical reality.
Okay, Vinay.
Sir, from my take is capacity building is required, because if this is to be implemented pan-India basis and mediation is like voluntary for pre-litigation, so obviously we need to gear up. The professionals particularly need to gear up, as Veena Madam also told us, and Amit sir also told us, that we need to build up. And obviously there is no dearth of professionals available, including the company secretary, chartered accountant, lawyers. Obviously everyone has to work in tandem and specifically understand the nuances as to how mediation is different. Like, it is not adversarial and you need to be within your lines, and at the same time make parties go for the settlement. So that is my take, sir.
Okay. Amitji.
Sir, mediation requires passion. So training is one thing, but you need to be passionate about giving it back to the society and your profession. That is one thing which cannot be contained in law.
Okay.
Now, the second thing is that I am a lawyer, maybe trained as mediator, but still skepticism doesn't go. So I have my skepticism about certain provisions of the Act, and I have missed no words in questioning or presenting them this evening. Even Mohit has not missed any words in showing his skepticism. So we continue to be lawyers. We cannot be diplomatic in our approach. So there are issues, but at the end of the day, welcome that at least now you can say that there is a law on mediation. Till now, whatever our trainers said was the law.
Okay. Madam, last word from your side.
Yes, so
Your voice, I think some problem with the network.
everybody has covered most
Madam, can
of
you?
the things. So I'll just sum up what they have said, and I'll say that. Am I audible?
You're
Just 1 minute. Am I audible now?
now audible. You can switch off your video and
Video. Okay, right. I'll say. Am I audible now?
Yes, yes.
Yes.
Hmm.
I'll say my co-panelists have summed up very nicely, and I will collate of mediation. And this means
I think there's some problem.
Am I
with the-
audible?
No, not
Just
audible.
1 minute.
Yeah.
I want to speak for a minute. Am I audible?
Now it is audible.
Just 1 minute, sir. So I'll just repeat what I said. I said all my panelists have said few things, the takeaways. Am I audible?
Yes, yes, yes.
So I will just sum up by saying the dawn of the golden era of mediation has begun, and the Mediation Act ensures that the future of India is resolution and not litigation.
Okay.
So we look at the future of India is resolution, as our CGI has also said, mediate and not litigate. Even Modi ji has said, our Prime Minister recently, mediation is the resolution, mediation is the solution. So we are looking at the dawn of this golden era, and that has begun. Very soon we will have certain areas which need some perfection. I'm sure our judicial system will help us. Our legislation will help us to get it a perfect legislation on this. But I'm very happy so far as the act overall is concerned. It's a very good piece of legislation. Few things, of course, we need to work.
Thank you very much, madam, because everything when it is coming, it requires some changes, and you cannot bring out 360-degree changes in a day.
Yes, sir.
Mediation is the future, no doubt. And I hope that mediation tourism will also start in India and make
Yes.
India as a hub for mediation. And no doubt there are some steps, and especially when this will be a part of the law, I'm finding in the corporate law, and I'm finding the professional like CA and CS and other professionals, those who are expert in their area, and these problems, because at sometimes what is happening, advocate is doing mediation, but they require some expert of that subject. So if a chartered accountant and company secretary, those who are expert in the subject and they are the mediator, it will be a golden point for them, and it can give a better result. I hope. Yes, sir. I hope that this particular thing, only thing is with the help of yours and Vinay's help, let's propagate and promote this mediation concept. I am aware that I'm in the profession since last so many years, but I have never tried how to become the arbitrator or how to become mediator. Sometimes what is happening, people think that this is the area which is alien from them, and this is a different area. If little bit education, and we can bring out more people who are expert, and especially the professional, those who are expert in their various area, can helpful and make this mediation system more perfect, more like you require sometimes doctor, you require engineer for valuation certain things. Yes, sir. Yeah, so it will helpful. So thank you very much, all my panelists, all my participants. We will share the presentation with you, and somebody has asked questions, so we will give you answer later on because time is not permitting us. So thank you very much, friends. This journey of knowledge sharing will continue, as you
Thank
are
you so much, sir.
Thank you
Thank
very
you.
much, sir. Sir, seeds of trading and imparting knowledge has been started from this webinar itself. And it is very heartening to know that 15th September, this act was notified and we are having webinar in such a small span of time. So this goes on to show the intent. And thank you very much for inviting us, and we'll keep in touch and we'll try to make sure that we build the capacity
Yeah,
together.
so you can give us a build capacity things and we will circulate to our participant.
Surely, sir.
More than 1 lakh registration in our complete all webinar of 146. Now we are reaching to 150 that webinar which we are organizing on 20th October, 150th webinar. We will invite everybody and friends. Now this journey of knowledge sharing will continue on next Friday, that is 6th. We are having our monthly program on updation of the last month. So complete updation of the 6th, before the 6th, what was the Friday. So we will discuss each and every aspect on corporate law, security law, FEMA, and insolvency. With this, thank you very much. See you on 6th at 4 o'clock. Thank you.
Thank you so much.
Thank you so much, sir. Thank you, team corporate. Thank you.